Everybody. We're happy to have you join us for our June meeting on the future of gender equity in education after 50 years of Title IX. I think we'll get started right away because we have a lot to learn from our distinguished speakers. Why don't we skip over and let Shawali continue on. Shawali, if you could also mention whatever your impression is of the new Title IX regulations that were released on Title IX's anniversary, the 23rd.
Yes, I will get it started. So my portion of the presentation is to provide a brief overview of the Title IX regulations or the proposed changes to the Title IX rule. And just let me do a brief introduction. Hi, everyone. My name is Shawali Patel, and I use she, her pronouns, and I'm the Director of Justice for Student Survivors and Senior Counsel at the National Women's Law Center. NWLC was actually founded in 1972, the same year that Title IX was enacted. So for the last 50 years, we've been working on Title IX issues and advocating for gender equity in education. And while we work on the issue broadly, our four main areas of focus currently are around addressing sex-based harassment in education, protections for LGBTQI+ students, protections for pregnant parenting students, and discriminatory discipline, particularly against girls of color, especially Black girls. And we do this work through policy, federal and administrative advocacy, as well as litigation. And NWLC as an organization works on a whole host of other issues, but given that our focus is on Title IX and I sit on our education team, I just wanted to share that. So this month was a big month because last week on June 23rd was the 50th anniversary of Title IX. And that also was the day that the Department of Education released proposed changes to the Title IX rule. Now, kind of backing up, Title IX of the Education Amendments is an important civil rights law that prohibits discrimination based on sex in education programs or activities. It's only 37 words long, but extremely broad. And so this rule touched on a few issues, which I'm going to briefly cover. One is protections against sex-based harassment, including sexual harassment in education, protections for pregnant parenting students, and for LGBTQI+ students. So it's a pretty gigantic rule. And with the preamble, it's about 700 pages. So I have not yet read the entire preamble. I read the rule, but the National Women's Law Center, through our ed team, we're looking at this deeply, and we will be developing an explainer with more details on the proposed changes and in comparison to what the current policy is. So stay tuned for that. Hopefully we'll have that available by next week sometime. So I'll try to answer your questions, but again, I haven't gone through the entire preamble. There might be some answers I don't have. So I'll start by sharing that these proposed changes undo a lot of the harmful rules that were put in place in 2020 by the Trump administration. I'll call these the 2020 rules that upended decades of Title IX policy and weakened protections against sexual harassment in education. So you remember that in May 2020, the Trump administration proposed changes to the Title IX rule that narrow the definition of sexual harassment, such that schools would have to dismiss Title IX complaints of harassment, sexual harassment that were not considered severe enough or objectively offensive enough. It required schools to dismiss Title IX complaints of harassment if it didn't occur in the right place. So if it didn't occur within an education program or activity, even if a student's education is impacted. So for example, even if a survivor is sharing a class with their rapist and is triggered and re-traumatized by being in that class with them, the DeVos rule doesn't require schools to address it if the assault occurred at like a private off-campus party, for example. Or, it also requires schools to dismiss complaints if the survivor is no longer enrolled, even if the harasser is still teaching at the school or they're enrolled there. So really what it did is it further swept or requires schools to sweep sexual harassment under the rug, even though it's so pervasive and has been pervasive for decades. Like, since the 80s, at least the data that I know of have been consistent that at least 1 in 5 to 1 in 4 undergraduate women experience sexual assault. About 1 in 5 girls in K-12 schools experience, I think middle to high school experience unwanted sexual comments and touching. Men are also sexually assaulted and harassed. For LGBTQI plus students, disabled students, students of color is much higher. So this is a huge issue. And because, well, let me take a step back. Not only did the DeVos rule limit what schools can respond to, but it also mandated traumatic and unfair grievance procedures only for sexual harassment complaints, and, like, for example, required direct live cross-examination on colleges and at colleges and universities. So this rule is so terrible that our organization and a few others, I know Amy's on, ACLU had also sued. We had sued the Department of Education to stop the Title IX rule in 2020. And we had received a partial victory, striking down a part of the rule last summer. But unfortunately, the entire rule still remains in effect until the Biden administration finishes the rulemaking process. So last Thursday was critical because this was when they actually showed us what they proposed to do in the changes, which remove much of the harmful changes that the Trump administration put into place. So, like, this narrowing of the definition, limitations based on location, requiring dismissal if the complainant's no longer there. Like, these are things that are not part of the proposed rule. And another notable change is that the grievance process that it outlines, which could allow investigations or hearings, it's not as prescriptive as the DeVos rule. It would apply to all sex discrimination complaints, and the Biden's proposed rule makes clear that discrimination based on sex includes discrimination based on sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, or gender identity. And so this is quite a significant change. And I just also wanted to say as a reminder that, these changes from the DeVos rule that really set sexual harassment complaints apart from any other type of student or employee misconduct by requiring unfair grievance procedures were rooted in deeply offensive and sexist stereotypes that label reports of sexual harassment as uniquely less credible than reports of other misconduct, therefore requiring special scrutiny of those reports. And in fact, the Nation did an expose. They released an article after conducting an investigation showing how men's rights advocates helped rewrite these rules. These fringe groups helped the Trump administration rewrite the Title IX rules. And another change that the proposed rule does is that it makes clear that discrimination against LGBTQI plus students is against the law. And this is very important because these students are much more likely than their peers to be bullied and assaulted and harassed at school. And as we're all seeing and knowing, there are attacks all across the country that are happening in states that are introducing laws to discriminate against them in violation of Title IX. And so this proposed rule is also consistent with the Supreme Court's decision in Bostock from a few years ago that clarifies that sex-based discrimination includes discrimination based on sexual orientation and gender identity or sex characteristics. So while these protections already exist under Title IX, it's still especially important that the NPRM clarifies that these protections exist. Again, especially because of these attacks that we're seeing in state legislators. And the proposed rule also makes clear that students should be able to access sex-separated spaces and education programs or activities consistent with their gender identity. And while the proposed rule affirms that Title IX protects LGBTQI plus students, from sex discrimination, the Biden administration indicated that it will engage in a separate rulemaking addressing access to athletics for trans students rather than kind of including it in this rule. And so we are hoping that the Biden administration moves swiftly in doing that. It's extremely important to affirm access to athletics for trans students and to be very explicit about that in the Title IX rule. And after I present, I'll share in the chat that a fact sheet that the National Women's Law Center recently developed about the rights of trans and intersex students to play in sports, pointing out how it's consistent with Title IX, how there hasn't been dominance in athletics by trans women and girls, and that many of these state laws are about policing, that limit access to sports are about policing who is or isn't a woman. And this often disproportionately falls on women of color and women and girls who don't fit sex stereotypes or, stereotypical notions of femininity. And that there are actual issues when it comes to gender inequity in athletics, like resource inequities, pay inequities for professional athletes, sexual abuse, rampant sexual abuse of student athletes, that these state legislators should instead be focused on if they really do care about gender equity in athletics. And, I also wanted to kind of lastly, and I'll answer some questions too if there are any, but mention how the Title IX rule would also ensure that pregnant parenting students receive greater support to complete their education. And, this is especially critical now, given the attacks on reproductive rights, right, and the overturning of Roe v. Wade. And also, because pregnant parenting students are often overlooked despite experiencing so many barriers to completing their education, including increased harassment, discrimination, and just lack of support from the institution that would allow them to continue to learn and succeed in school. So, and the Title IX regulations regarding pregnancy, related medical conditions, and parental status that were introduced in 1975 have not been substantially changed since. So these proposed changes from the Biden administration would clarify that lactation is a pregnancy-related medical condition and that schools must provide reasonable supports to lactating students, including time and a sanitary space to express breast milk, an opportunity to make up work missed while expressing breast milk. It would clarify that Title IX coordinators have to receive adequate training on the rights of pregnant parenting students and inform students, faculty, and staff of their rights under Title IX. Would require schools to provide reasonable modifications to pregnant students, which may include access to an elevator or larger desk, and also would require access to voluntary leave of absences. And so, again, this is a very high level overview of the changes, but it is quite a major NPRM, and the comment period has not yet begun because the Department of Education has not yet published the proposed rule or the NPRM, the notice of proposed rulemaking, in the Federal Register, which is through that will actually begin the 60-day comment period. And that through the Federal Register, anyone will be able to submit written comments to the Department of Ed on the proposed changes, including recommendations for anything that should be changed, that you believe should be changed. So that should be coming out soon. And again, the National Women's Law Center will be developing resources, including an explainer that provides more detail on the changes. And I am going to go ahead and link to some documents in the chat, which I think are helpful. One is a disinformation fact sheet that the NWLC developed, kind of countering some of the myths and the disinformation about Title IX and its protections for sexual harassment, myths that have been mostly perpetuated and spread by men's rights advocates and also the Trump administration. And I will be sharing the fact sheet addressing inclusive athletic policies. And then finally, we'll be sharing some resources about the Trump Title IX rule and the result of the lawsuit that we have received a partial victory in. last year. So I'll leave it at that, and I look forward to your questions. Thank you.
This is David Martinez. I actually have a question. Can you hear me?
Yes.
Perfect. Yeah, I was wondering what rules were proposed or enacted by the Trump administration that affected athletics. If you knew of any rules in particular that affected athletics during the Trump administration.
There were.
And how those rules might be changed, coming, for the upcoming rules that might be proposed by the Biden administration.
Yeah, that's a good question. So there aren't rules. So the Trump Title IX rule changes did not focus on athletics. They focused on sexual harassment. So they've, weakened protections that existed for decades. And I'll put a link to an explainer that we had developed in response to the Trump Title IX rule. And then the other thing that the Trump rule did, which I didn't mention, is they made two separate changes in 2020 that changed Title IX's religious exemption. So Title IX has a religious exemption that allows institutions that are controlled by a religious institution to claim an exemption from not the entire Title IX regulation, but the provisions of parts of Title IX that conflict with that institution's religious tenets. So as I said earlier, Title IX is massive and the regs are massive. You can't just get a blanket exemption to comply with all of it, but institutions are able to claim that they're exempt to certain provisions. And so what the Trump administration did with the religious exemptions is that they made it easier for schools to claim an exemption with less transparency, meaning that it's less likely for students and their families to know if their institution is claiming an exemption to discriminate, which is harmful and also, I would argue, inconsistent with other parts of the Title IX rule that requires schools to publish and make very clear what their non-discrimination policies are. If you have to publish and let students and their families know that you're not going to discriminate based on sex in compliance with Title IX, then how could you also not let them know at the same time you're exempt from certain provisions of Title IX in order to discriminate? Anyways, so there's less transparency, and also the second change they made in 2020 allows more institutions, even if they're not controlled by a religious organization, to claim an exemption. And typically these exemptions have been applied to discriminate against women, against pregnant parenting students, students who were accessing abortion or birth control, and LGBTQI plus students, especially after the Department of Ed under the Obama administration increased its enforcement of Title IX with respect to protections for trans and non-binary students. So this much broader than your question, David, which I guess could have been a simple no. The Trump administration didn't address athletic, but I just wanted to use this as an opportunity to explain other changes that I didn't mention.
Thank you so much. No, I really do appreciate that.
Jeanette is our Vice President for Legal Affairs of the Clearinghouse on Women's Issues. And she was a leader for many years in the Office for Civil Rights Program Legal. And at times, she was even the acting Assistant Secretary for Civil Rights in the U.S. Department of Education. Jeanette is going to fill us in on background and history, which was supposed to be our first presentation, but she had technical difficulties. So now we get to learn from Jeanette.
Thank you. Thank you, Sue. And thank you, Shawali. The National Women's Law Center has provided so many resources for us as we have been faced with the challenge of the Trump administration, and particularly Secretary DeVos, former Secretary DeVos, and look forward to working with you on this next round of comments. First of all, let me say happy birthday, Title IX, 50th anniversary, Thursday, June the 23rd. 1972, 50 years ago, was a banner year for women. The Equal Rights Amendment was introduced in the Senate in March. Title IX was signed into law by the president, as I said, on June 23rd. And in January, actually of 73, but discussed all the way through 72, the Supreme Court announced Roe v. Wade. 50 years later, today, as we have this meeting together, only Title IX remains standing. So there's a lot for us to do. I want to review for you how Title IX passed and how it has endured. I'll talk about the actual, quickly about the history of the passage of Title IX. It gives us some lessons in civil rights legislation. And then I'll review the challenges which continue today to the enforcement of Title IX and how those challenges were met by the courts, by Congress, by activist groups like and the National Women's Law Center, and by OCR in the Department of Ed, where I spent over 36 years in that department and in the Department of Justice, litigating Title IX and 14th Amendment issues. Let me go to the history. Title IX was enacted, and it consists of 27 words. No person in the United States shall, on the basis of sex, be excluded from participation, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. Representative Edith Green from Oregon, Representative Patsy Mink from Hawaii, Senator Birch Bayh from Indiana, and our own Bernie Standard, activist and godmother of Title IX, were all leaders in getting Title IX passed. The two congressional representatives looked to the Civil Rights Act of 1964 for language, and they considered amending that to add Title IX provisions. The 64 Civil Rights Act prohibits discrimination based on race, in employment, race, and let me see, among other provisions, discriminate workplace employment on the basis of race and sex in federally funded programs. However, the two Congresswomen decided it was too difficult to amend the Civil Rights Act and turned to an amendment of the higher education amendments, which were coming up in 1972, to add another title, Title IX, to prohibit discrimination based on gender in higher education institutions receiving federal financial assistance. And they held hearings as a precursor, and Title IX was passed. And originally, they envisioned that it would assist women to get admissions to higher education and to professional schools like medical school and law and PhDs. So it's interesting how it has become a banner, not only for athletics, which it somehow has, and maybe in large part because of professional athletes and the Olympics, but is part of the Me Too movement, sex harassment, which Shawali informed us about, and the whole issue, it has become an international banner for the rights of women. And I'll talk a little bit about that. But let me tell you about the challenges, the early challenges, particularly. In 1979, after the law was passed in 1975, the Office of the Department of Health, Education, and Welfare, the precursor department to the Education Department and the Department of Health and Human Services, issued guidelines. And in 1979, a woman by the name of Geraldine Cannon was denied admissions to the University of Chicago Medical School based on her gender and her age. She was in her 30s. And they claimed that people in their 30s wouldn't live long enough to really benefit medical schools from investing in them in a medical education. Can you imagine that? The Geraldine Cannon sued under Title IX and claimed that the age limitation had a disparate impact on women because women frequently had child-rearing responsibilities and delayed, particularly postgraduate education. And furthermore, women lived longer on actuarial tables which she submitted, lived longer than men. The lower courts, both the district court and the Seventh Circuit, affirmed the right of the University of Chicago Medical School to use these standards and deny Geraldine Cannon admissions. The Supreme Court in 1979 overturned those determinations and understood what Geraldine Cannon was saying, and said that the lower courts, which had said the only way to enforce Title IX was through the administrative process of terminating federal funds, and that Geraldine Cannon didn't really have standing to bring her suit. So the Supreme Court said not only did she have standing and read a private right of action into Title IX, but the University of Chicago had to admit her to the medical school. So the Supreme Court took up the rights of women back in 1979 and furthered the private right to sue under Title IX. An important holding, because not only did they say this right to sue applied to Title IX, but it also applied to Title VI of the Civil Rights Act of 1964, to the Rehabilitation Act of 1973, and to the Age Discrimination Act. So that's one case where the Supreme Court found in favor of women. Wish we had that Supreme Court today. Yeah. After the regulations were promulgated and enforcement began to address the rights of girls in interscholastic sports, there was a remarkable increase in the number of high school, excuse me, high school women who wanted to participate in sports. So OCR, which was now in the need to address participation of women in intercollegiate athletics, had been receiving many complaints about the lack of opportunity and the treatment of women in athletics. And in 1979, after finally addressing these lawsuits which had piled up, and actually the federal agencies had to do so with the push of what was called the Adams Orders. And the NAACP and the Women's Equity Action League filed suit, basically a mandamus suit, and said to the Department of HEW and the Office for Civil Rights, do your job, you federal workers, and start enforcing Title IX. And as a result of that, the office was required to hire more attorneys and to turn their attention to the athletics issue. I was one of those attorneys that was hired. And my first responsibility was to work on a team of primarily women who were charged with the task of writing guidance on how to define equity in intercollegiate athletics, which at that time was, it was, they were so disparate. It was a real Sisyphus kind of mountain that we had to climb. What we did is we issued a intercollegiate athletic policy in 1979, and then we went out to our 10 regional offices and started training them on how to investigate Title IX, these complaints that we had been receiving. And it was 1979. We were worried that Reagan had won the election, and in 1980 he was going to come in and had already threatened to cease the activity, which had gotten a lot of attention, of investigating Title IX athletics. And I actually met my 6'5" former basketball player husband, who was assigned to a team that I was on to work on these cases and get it done before January, when the Reagan administration was coming in. Tom, my husband, and other athletes who had far more athletic experience than the women who in Washington who we were doing the training, but they were giving us the inside scoop on the real world of intercollegiate athletics. We issued letters, and it became a real big project over the years. Although it was challenged hugely in 1984, I was on my way to issue a letter of finding violations in the University of Alaska athletic program, and to work with them on resolving those issues under our 79 guidance and our standards, when at a layover in Seattle, 1984, I was called by headquarters and said, "Come home immediately." I said, "But my bags are on their way to Alaska." And they said, "Come home immediately." The Supreme Court had just issued an opinion in Grove City versus Bell, in which they said that Title IX applied only to those specific programs or activities that directly received or directly benefited from federal financial assistance, and that Title IX did not apply to the entire institution. And they went so far as to say, and perhaps it's only to the Federal Financial Aid Office. So I went back and we licked our wounds and decided what we were going to do with this Supreme Court opinion. But Congress came to our rescue, and maybe Congress will come to our rescue with regard to this Roe v. Wade situation. Anyway, Congress passed the Civil Rights Restoration Act, and the Civil Rights Restoration Act determined that the entire institution was responsible to accept and to investigate complaints of Title IX. And so we were back in business. The other issue, which I'll touch briefly because Shawali provided us a lot of information on sexual harassment, but it is it is definitely one of the issues that Title IX has been active in. I was assigned in 1981 to a Title IX complaint against Weber State University in Utah, one of several complaints of sexual harassment, just like we got a lot of complaints in athletics at that time. We were receiving a lot of complaints on this new phenomenon called sexual harassment. This was a case where a young girl was required, a co-ed was required to sit on the lap of the financial aid officer while he got details of her eligibility for either a scholarship, an award, or a loan. And she filed a complaint with our Denver regional office, and they wanted assistance on what they should do with this and other offices. So in 1981, we issued we recognized in a policy memo that sexual harassment was covered by Title IX, and we determined that sexual harassment, the definition, that sexual harassment consists of verbal or physical conduct of a sexual nature imposed on the basis of sex by an employee or agent of a recipient that denies, limits, provides different, or conditions the provision of aid, benefits, or services or treatment protected under Title IX. So Shawali provided us the history and the future of Title IX. Let me close with some thoughts about the future of Title IX and the future of athletics. As I said earlier, Title IX has been somewhat of a bellwether and an inspiration. We cheer the fact that women participants in athletics increased after the participation of collegiate athletes due in large part to Title IX, and in fact came home with more medals than the men. And we can't overlook the fact that the U.S. women's soccer team now has equal pay as compared with the support of the men's U.S. soccer team now has equal pay. They both now are equalized in terms of their compensation. So the other issue I want to mention briefly is there's a movement to unionize collegiate athletes. It's a developing issue that Senator Chris Murphy of Connecticut is addressing in proposed legislation. And there's some discussion that perhaps collective bargaining can assist in the equalization of the rights of women athletes, and particularly in what is increasingly may be considered pay, and that is scholarships. Our athletic scholarships in the collective bargaining language, salaries. That's an issue that is likely to come up. The other one is something called NIL, which is an acronym, NIL, and it stands for an athlete's name, image, and likeness. And whether an athlete's name, image, and likeness belongs to them, belongs to the school, or belongs to the conference, who is making money on NIL? Well, thus far it hasn't been, at least above board, the athlete, and there is much discussion about that. And finally, I want to mention that Cory Booker from New Jersey has introduced a bill called the College Athletes Bill of Rights. And in it, it contains a reference that that 90% of all the programs in colleges throughout the country are not complying with Title IX. I don't have a cite to that. I heard his speech at a recent conference. In that Athletes Bill of Rights, Cory Booker proposed that Title IX should go forward with more teeth and needed more enforcement under Title IX. So, and finally, I do want to mention that the whole issue of affirmative action under Title IX may be under scrutiny, not so much under Title IX and what OCR enforces, but under executive orders that require higher education to take affirmative action because of contract compliance. And this is something that Bunny Sandler, our godmother of Title IX, has always enforced. And there is some concern that because of the underpinnings of Roe v. Wade, that there are other issues, including the possibility of affirmative action, will be under further scrutiny by this conservative Supreme Court. I've gone way off into the future after going way back in the past. I'm open to any questions. Thank you for the opportunity to share this
Thanks
with
very
you.
much, Jeanette. I think if we can skip and hold questions until the end, it would be good. And now, if we can hear from Amy Katz, who is contributing attorney, cooperating attorney at the American Civil Liberties Union. Amy, take it away.
Okay. First of all, thanks, Sue and Connie, for this invitation. The views I express here are mine and not that of any organization I may be working with. That said, I am a cooperating attorney at the ACLU, which means I'm not on regular staff. The ACLU Women's Rights Project was founded also 50 years ago. So 50 years ago is 1972 was a banner year. It was founded by Ruth Bader Ginsburg. And we follow in her footsteps. A lot of what I'm talking about is covered by a report that was issued by the National Coalition for Women and Girls in Education, the NCWGE, called Title IX at 50, and I will drop a link for that. I'm a co-author. Shawali really held the laboring oar to whip everyone in place. And Sue is an author, and I think Connie might be. I mean, lots of people here had a hand in it. What I hate to say, I'm talking as Jeanette did, sort of a tale of progress and a tale of regression. One is sex segregated education. In 1975, when the Department of Education issued its Title IX regulations, it was actually the Department of Health, Education, and Welfare. It was clear that you could not operate separate classrooms or courses based on sex. All right, and that's rooted deeply in the intention of Title IX to eliminate the requirement that girls take home ec and boys take shop. In other words, girls take classes that probably give them no economic future, and boys take classes that give them real job skills. And that was a bright line, and it was easy to identify, right? People just, there may have been some single sex classes, but there weren't many. It was generally forbidden. In 2002, there was a No Child Left Behind was enacted. And at that time, for many years, there had been a push to allow single sex education by conservatives. And they found an unlikely ally in Hillary Clinton, who was at that time New York's senator. Hillary loved Wellesley. She thought it was a phenomenal environment. I won't deny her that Wellesley must have been a phenomenal place for her. Public schools are not Wellesley. However, she joined Kay Bailey Hutchinson in introducing a provision that there would be some funding for innovative programs that involved single-sex education, and asking the Department of Education to issue guidance as to how that could happen. What Hillary had in mind, as she basically wrote in comments when the Department of Education didn't do what she wanted, was how could you do affirmative action? How could you have programs that are targeted to help girls in areas where they had been left behind, like STEM? That's not what the Department of Education came out with. The original proposal actually opened the floodgates entirely in response to comments like Senator Clinton's, like those of any organization participating here today. They cut back, they set up a whole series of barriers. Those barriers were not understood, that how you justified a program, what kind of alternatives you had to have, that you had to have comparable coeducational alternatives. And what happened as a result of the 2006 regulations was that several people found that this was a business opportunity for themselves to peddle single-sex education, and more importantly, their own personal consulting skills in implementing that education. And so the views that many people heard about what the regulations done were actually put forward by a doctor/psychologist called Leonard Sachs, who wrote a book called Why Gender Matters, and put forth the idea that boys' and girls' brains were fundamentally different, and that they developed differently and learned differently, and were so different that boys and girls belong in separate classrooms. This was it was wrong, both in terms of the science behind it, and it was wrong in terms of how they were representing that it could be done, because the regulations really did not allow just do it. And so, and the other person was Michael Gurian, who still runs the Gurian Institute and trains teachers throughout the country. And Leonard Sachs is still speaking. And so this is not dead, all right? They keeps coming back. So it was based on different learning abilities. Girls can only learn math with word problems. Specific examples like, if 3 dresses and 4 shirts cost $150, what's the cost of each skirt and each, there were math problems that were not abstract. They were very concrete. And at the same time, they said, boys love abstract mathematics. They don't want word problems. They want to hear 2x + 4y = 75. And that's, that gets them excited. And so they should be taught differently. They should be in different classrooms. Boys shouldn't be asked about their feelings about anything. Boys rebel, they close up if you ask them how they feel about something, or how does a character in a book feel. So don't talk to boys about feelings, but should always talk about feelings, talk about how they feel about a book. Boys like action books, girls like romance books. These are all sex stereotypes, except that, as I've said many times, people don't know what a sex stereotype is when they're articulating them. And they said separate the classrooms, and numerous school districts did, and some still do, although far fewer than did in the immediate wake of the 2006 regulations. Now that's for two reasons. One, the ACLU sued school districts for doing this. We found falsified data trying to substantiate improved performance when there was no improved performance. We found that they were involuntary programs because people didn't actually want to sign their kids up for single-sex classes. They would just put the kids in single-sex classes and say, this is the best thing for your child. And maybe if they tried to get out of the program, they'd push them back into it, say, no, 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 you don't want to take your child out of this program. Your child really belongs there. So we had a series of victories, a major one saying that you have to get affirmative consent from a parent before you can put a child into a single-sex program. They have to sign up. It's not sufficient to just throw them in and say, well, maybe you can get out of it. And the other thing that was going on was that organizations like ACLU, NWLC, NCWGE as a whole, Feminist Majority, worked with the Department of Education to come out with a guidance explaining what the regulations actually mean. It is an insanely long guidance called FAQs, and I will post a link to them. And basically, there are a lot of hoops that have to be jumped through in order to establish a single-sex class. It is almost, I won't say impossible, but close to. However, at the same time, they said you could have a single-sex school as long as you had a comparable single-sex school or co-ed school for people who were excluded from that one, or I would say opposite sex, but that is more problematic and harder to stop. There are not that many single-sex programs, single-sex schools existing in the country, but there are enough to be disturbing right now. Before the change in the regulations in 2006, it was assumed that Title IX, while specifically allowing single-sex schools admissions programs. So they were trying not to mess with historically single-sex public schools, those handful that existed. And everyone assumed that you couldn't have another single-sex school created. But as a result of the 2006 change in the regulations, everyone suddenly woke up and said, oh, the Title IX doesn't apply. We can have single-sex schools. And those are harder to shut down. The Constitution does apply, so they can't be based on sex stereotypes. Everybody has to get equivalent educations, but it's trickier, and you also need a plaintiff and in order to challenge it. And so that would have to be someone who wanted to go to the school from which they were excluded, and finding people, a boy who says he wants to go to the girls' school or a girl who says she wants to go to the boys' school is not the easiest thing these days. So the schools continue to exist. Now, it's the position of the NCWGE that the best course here is to rescind the regulation because people don't understand how they have to jump through all the hoops to actually have lawful single-sex classes. And it'll be better to have a bright line. All right, so it was much easier in 1975 when you just said no single-sex classes. Now it's, well, single-sex, if you jump through the following 20 hoops, people don't, the regulation was dense. The guidance provides a lot of information, but also is far more complicated than most people can deal with. And as a result, we're back to, it's whatever Leonard Sachs and Michael Gorian tells them the requirements are. Okay, because these are the consultants they hired to do it. And I'd like to say that we shut them all down before, but the Maryland now has a single-sex initiative, and Gorian and Sachs were consultants on it, and their fingerprints are all over the plan to establish single-sex programs in the state of Maryland, because this is innovative. Now, I would like to question how something that is so old suddenly became innovative. But we can't go there. But then it's not so innovative. Working with psychologists and education specialists, we've learned that it's not beneficial to be in sex segregated environments, that children need to learn together in a cooperative environment where they're working towards a common goal, even if that common goal is producing a lab report. Boys and girls don't learn differently. How they absorb information, how they learn is the same. Our brains are not particularly different. There's just really no justification for most sex segregation, and certainly not any justification based on the concept that we boys and girls learn differently or have different brains. So that brings us to the question of how the NCWGE simultaneously suggests that we have affirmative action in career and technical education programs, STEM programs, and have some race and gender conscious programs. And the answer is affirmative action, which unfortunately, as Jeanette just mentioned, may not be something available in the future, but it may or may not be necessary. I mean, we can look today at the progress. I mean, the biggest, I think the biggest changes besides sports and sexual harassment have been in the professional schools. Law school and medical school are now 50% female. Now, it took 50 years to get there, but we got basically full equity there. So the career and technical education, there had been the Biden administration had issued a guidance and that was on the hit list for the Trump administration. So it was a short-lived guidance explaining how you could do affirmative action in CTE programs, career and technical education. The guidance isn't wrong, so the recommendations are still good. They're just not sitting out there as an official recommendation. You can do lots of things. You can recruit girls into programs where they have been, where you want to increase their enrollment because they're historically underrepresented. But bottom line, the ACLU, I won't say the ACLU, I don't think it's a good idea to have, you wouldn't want to have a construction school for girls. All right, let's besides the fact that the Department of Education says you can't do any single sex CTE programs, because that was at the heart of Title IX, and the Title IX debates back in the 70s was that girls were being discriminated against in vocational education programs. But why wouldn't it be a good idea? Well, it wouldn't be a good idea because, one, while you'd have girls learning their skills, you'd have boys learning separately and not working with those girls in class, not seeing them as competent peers. And equal education is a wonderful goal, but the real goal is to be able to go out into the workplace and have equality for your life, not just for equality in school. And if boys are not in the same classroom with girls and learning with them, then their mindset that they're inherently better at wood shop or whatever is not going to be dispelled. They need to be together in order to do that. Now, the question is, how do you get the girls in the room to begin with? I've got lots of ideas. You can actually assign, it doesn't have to be an elective. You can have everybody rotate through all of your vocational programs so that you don't, it's not what do you want to sign up for, but everybody gets a semester, 6 weeks, whatever, of whatever you're offering, shop and design. And it used to be cosmetology. I will say that the city of New York, I've discovered, has only one cosmetology program left in its high schools. This is a good thing because it used to be the female ghetto. And they'd have gender balance in the school because they had a cosmetology program for girls. And then the boys did all the stuff that actually paid money. But you can bring in speakers so that people, if you can see it, you can conceive of it, you can bring in women in all sorts of non-traditional trades to speak to the girls. You don't have to balance it with men. They don't have to speak to the girls alone. They speak to everybody. They speak to a classroom. It's as important for boys to see role models who are female as it is for females to see female role models. Boys have to know that women belong in every space. So our recommendation from the NCWG is basically don't do single sex classes. You can do outreach in other ways. Now, I'm going to flip this because so what we have here is we have something where the rule in 1975 was a lot better than the rules today. And there was a lot of mischief along the way and a lot of litigation along the way. Now, there's another area where exactly the same thing has happened, and that is dress codes. In 1975, the original regulations prohibited discriminatory rules of appearance, hair length, clothing, whatever it was, jewelry, can't have sex discrimination. And back in the 70s, girls were, pushing to wear pants anyway. And so that just became acceptable everywhere. The blowback was in hair length. Long hair on boys was you were perceived to be a hippie, anti-war, any number of things. You violated all sorts of gender stereotypes. And there were lots of complaints from boys to the Department of Education about their school's hair length requirements. Girls could have any length hair and boys had to have short cropped hair above their necks or whatever. Comes the Reagan administration, that one that Jeanette loves so much. And Reagan had a push to eliminate federal regulation in general and sent a directive to all the agencies to eliminate whatever regulations you can, basically. And so the Department of Education eliminated exactly one regulation, and that was the regulation prohibiting discriminatory codes of appearance. Didn't change their general prohibition on discrimination. I mean, they couldn't change Title IX, but they just said, oh, it's up to the local people. It's not our business to enforce it. And they, sort of walked away from it. So they never actually, so they stopped for a long time in any event investigating hair length cases and dress code cases. Now, you would think that a lot of these, you would think that who's discriminating, not allowing girls to wear pants? Well, I have the school that did and does, charter school in North Carolina called Charter Day School, founded in the 1990s. Said no pants for girls. Girls must wear skirts. Skirts, dresses, they expanded to include skirts in a very magnanimous move. But girls have to wear, girls have to wear them for gym days, but that's it. They have to wear sweatsuits for gym days, recognizing that you can't move around and be comfortable, and if you're in a skirt, you have to be wearing sweats or shorts. We got called at the ACLU by a mother of a kindergarten girl who she had enrolled her son and daughter in this school. She hadn't read the dress code. She knew they had a uniform. She had looked at the boys' dress code for her son, who was older and, seemed reasonable. And she was sitting in a meeting for parent orientation and said, when they said that girls have to wear skirts, she said, "Say what?" And that has led to a 7-year odyssey in the federal courts over whether or not girls can be compelled to wear skirts to school. I am thrilled to say that at this point, 7 years to the month since that parent meeting took place, the federal court for the Fourth Circuit, the Court of Appeals, sitting en banc, that means 16 judges, 13 ruled that Title IX applies to dress codes and that prohibiting girls from wearing skirts constitutes sex discrimination. I mean, requiring girls or to wear skirts, prohibiting them from wearing pants constitutes sex discrimination. There were 3 judges who thought that it was okay, but even most of the conservative judges on the bench went with us because they said Title IX is very clear. It says no discrimination. Even if the Department of Education rescinded a regulation, even if they had substantively said you can discriminate based on dress, that would be contrary to Title IX. Title IX actually has a few more words than people like to talk about because the important part is the no discrimination, but it has a lot of exceptions in it. It has that exception saying that you can have historically single-sex schools could continue, that you can have single-sex secondary schools, and military academies are exempt. So there's a laundry list of exemptions, and in fact, it doesn't apply to Girl Scouts and Boy Scouts and other voluntary organizations. So the court said, hey, it's not just that there's prohibition on discrimination, there are exemptions, and this isn't one of them. So despite what our defendants said, and yes, this school is vigorously fighting this, and we anticipate will probably seek review by the Supreme Court, that despite their theory that withdrawing a regulation is an interpretation that Title IX does not apply, they said, no, if it wasn't specifically exempted in the statute, it is covered. So dress codes are covered. Now, as to, there is also a parallel claim for constitutional violation here, that a discriminatory dress code violates the Equal Protection Clause. And there we have a ruling that the charter school is a state actor, meaning they are subject to the Constitution. This is something that some commentators on the more right-wing side think means the death of charter schools, because apparently you can only innovate, you know, like that word keeps coming back, you can only innovate in charter schools by discriminating. And I should just backtrack and say that the innovation here was that the founder of the school believed in chivalry. He actually cited Columbine and said that the school was founded in the wake of Columbine. And I think the fundamental theory is if girls had been wearing skirts at Columbine High School, they would not have been shot because the shooter would have aimed at the boys or something. It makes no sense. He also said that he wanted to have a school that promotes chivalry because girls are fragile flowers who need protection. And he wants boys to hold umbrellas open and hold doors open, not like girls can't carry their own umbrellas and you shouldn't just hold the door open for the person behind you. And I will get you a link because reading these opinions can be very entertaining, particularly the majority opinion attacking chivalry and explaining that chivalry was no bed of roses for the women at the time who could be subject to marital rape and any number of other things. There is a dissent saying that chivalry was wonderful. So we are back in the Middle Ages here. We are fighting about what was chivalry, good or bad. But ultimately it comes back to, now we had wanted a change, we had recommended a change in the federal regulations to specifically prohibit discriminatory dress codes. That has not directly been addressed in the proposal that was, that came out last week. But as Shawali mentioned, it does prohibit use of stereotypes. And girls should wear skirts is a stereotype, or girls do wear skirts is a stereotype. So, and it was already covered by thou shalt not discriminate. Although it would be nice to have a regulation expressly mentioning dress codes, there is just a grassroots movement against discriminatory dress codes at this point. Girls consider it part of their bodily autonomy, which they of course were told last week they don't have. But girls are fighting against regulations that where they see okay, it's not necessarily even an expressly discriminatory regulation, it is discriminatory enforcement, where schools will say shorts have to be of a certain length, and then boys walk in with running shorts that are microscopic and nobody does anything about it. Nobody cares. And when their sisters, literally their sisters, walk in the same kind of shorts, the girls get dress coded. We're involved with a school in St. Johns County, Florida, has had 83% of dress code violations are issued against girls. They've eliminated their facially discriminatory requirements, but they still have disparate enforcement. There is an ongoing Department of Education investigation into that district for actively creating a hostile environment for girls. That is what they view the enforcement as. It's not just girls walk in and their bodies are being scrutinized, they're being pulled out of class, they're being told in the hallway that they have to go put a sweatshirt on, or more bizarrely, if they are wearing sweatshirts, they're asked to remove the sweatshirt to find out what is underneath and whether what is underneath complies with dress code, even if the girl has no intention of removing that sweatshirt in her classroom. So kudos to the Department of Education for thinking maybe this is just a hostile environment for girls because girls are so stressed when they walk into some of the schools in this district. Thank you, Shawali, for posting your excellent work on dress codes. And I think that's where I'm going to end. So as I said, some things were much better in 1975. In fact, it looks like a lot of things were a lot better in 1975.
Thank you so much, Amy. I'm now going to give a shorter presentation on Title IX coordinators. Our other presenters made it clear that ending sex discrimination under Title IX is very complicated and it's ongoing despite 50 years of progress. Since ending sex discrimination is so complex and challenging, it is clear why we are having well-informed Title IX coordinators and why it's so important to have them. We need many Title IX experts to guide our schools in what they should do and how they should act proactively to end sex discrimination. The 1975 Title IX regulations required recipients of federal financial assistance for education programs and activities. As my IX regulations required recipients of federal financial assistance for education programs and activities at all levels of governance, from state education agencies to local education agencies or school districts, and to their individual pre-K through 12 schools, and also to institutions of higher ed. All were expected to have Title IX coordinators to guide them in the implementation of ending sex discrimination. In our studies of Title IX coordinators, the Feminist Majority Foundation estimated that there should be over 100,000 US Title IX coordinators, but in 2016, we were only able to identify 2,300 Title IX coordinators that were listed by name in Department of Education databases. Also, very few states encouraged the appointment of Title IX coordinators in the nation's 98,000 or so public K through 12 schools. And we think that it's very hard to implement Title IX if you don't have someone who really knows what it's about and can push for ending sex discrimination. Title IX coordinators are needed to train staff and students and community members on their rights and responsibilities to end sex discrimination, recognize the different variety of types of sex discrimination, many of which you heard about from our previous presenters, and from athletics and academics to sexual harassment and discrimination against LGBTQI plus individuals. They are needed to administer grievance procedures equitably, efficiently, and effectively, to offer and coordinate supportive measures to those involved in discrimination complaints, to restore their access to education opportunities, to take appropriate and prompt steps to ensure that discrimination ends and it does not reoccur, and that appropriate remedies are provided for those suffering discrimination, and to work with others, including Title IX coordinators at all levels of education and other equity coordinators, such as those who are charged with ending discrimination related to race, color, nationality, and disability, and to learn from and support each other and resolve intersectional discrimination challenges. It is important to have clear and comprehensive Title IX regulations, and thankfully the new Department of Education regulations that we've just heard about are very helpful, but they are not comprehensive in coverage, as our presenters pointed out, even though they are over 700 pages long. They did eliminate some outdated provisions, and they were a great improvement over the 2020 regulations that were issued by Betsy DeVos. In our National Coalition for Women and Girls in Education report, we recommended that ED clearly recommend that individual public K through 12 schools have their own Title IX coordinators, but page 131 of the regulations is on the correct track, but it says through its examples that it does not recommend that Title IX coordinators be assigned to each of the pre-K through 12 schools, which is what we recommended in our coalition report. Instead, they say that the local school districts can appoint a Title IX coordinator and designate as many other Title IX coordinator helpers, but not official Title IX coordinators, to help them implement Title IX, and that they, the school district Title IX coordinator, should be the lead person of taking responsibility for that. We will hope to write some comments to the Department of Education to change this tiny aspect of their Title IX regulations to make it clear that there should be 100,000 plus Title IX coordinators, including Title IX coordinators in each of the K through 12 schools, and that there can be many more. And then of course there can be many in their offices that are designated to help the Title IX coordinators. I'd like to quickly end with some key recommendations that we really want to expand the number of appointed and well-trained Title IX coordinators, including in individual K through 12 schools, not just school districts. And we want to have the Title IX official Title IX regulation that the Biden administration will issue, make that very clear that there should be many active, well-trained Title IX coordinators. we think that the department should maintain pre-government run databases to help people find their Title IX coordinators and to help the Title IX coordinators and other gender equity experts and supporters communicate with each other, that there should be federal resources for Title IX coordinators for their training, for information on their best practices and a website to help, and the Title IX coordinators should not just be there for enforcement, which is a major focus of the new Title IX regulations. It's important, but we think that they should be catalysts for proactive action to stop and prevent sex discrimination. And finally, and very importantly, we think that the Department of Education is in a position to implement many of the Gender Equity Education Act provisions, such as establishing an Office for Gender Equity in the Department of Education, developing federal websites that have resources on preventing sex discrimination, and that, of course, the Gender Equity Education Act should be passed to get lots more resources to help Title IX coordinators.
This is Karen Humphrey from California.
Thank you, Karen.
And the main question I've always wondered about is whether any Title IX violation will ever result in the removal of federal funds from any institution. When I left education 10 years ago, there had been no removal of funds. And I guess I understand why it should be a last resort, but I guess my question is there real seriousness in the Department of Education about enforcing Title IX in a meaningful way? And would the actual removal of funds be a helpful message?
I'll try that.
Great, thank you.
I think we may have removed funds from one Michigan school district. I can't remember the name of it, but the answer is it's very rarely done. And within the Department of Education, it was referred to as the H-bomb. There is another alternative to terminating and forever rendering the recipient unable to receive aid, federal aid, and that is to refer the lack of performance and the inequity, the discrimination finding to the Department of Justice for specific performance. And that has been done very rarely, but it has been done. I can't off the top of my head tell you what are those cases, but we have within the staff, we always said we ceaselessly negotiate, and we have had with time frames, and that seems to be the preference, in large part because to terminate funds actually hurts the students eventually, and the issue is to try to get the rights of students.
Can I clarify? The removal of funds would be permanent? I assumed that the removal of funds would be for a period of time until they fix things, because there are a lot of compliance agreements that are never fully implemented. So, but if permanent removal of funds, I wouldn't even support that.
What I'm referring to is in the determination to remove funds, there is language that said, and they continue to be ineligible for funds unless they come into compliance.
Okay.
So it's not permanent, but it addresses eligibility. Perhaps I overstated it, but they will continue to be ineligible until they come into compliance. But
Thank you
as
very
I
much.
said, it's not permanent. I mean, it's frequently used, infrequently used, sorry.
Where we see some rights being eroded, I just wondered if anyone knew of efforts to mobilize to keep Title IX protections and not go backwards on this. Are you aware of extra efforts to preserve Title IX benefits?
As I mentioned in my closing comments, Cory Booker has a Bill of Rights for athletes, and it references the more vigorous enforcement of Title IX, and it does address athletes, but I imagine it could be adopted beyond the Bill of Rights for athletes, but that's the only thing I'm aware of. Right now, it doesn't seem that Title IX is in jeopardy, like, of course, Roe v. Wade and the Equal Rights Amendment, which you worked on so vigorously, Holly. But so
That
we're
needs
hoping.
help too.
I would say the National Coalition for Women and Girls in Education would be the starting point. Every organization that is really concerned with enforcing and expanding and improving Title IX is really a part of that group. So we haven't mobilized for its removal, but I think that would be a good place to start for any issues around it.
Yeah, and there have also been more grassroots efforts from girls themselves to assert their rights, and in particular in the sexual assault arena with groups like Know Your Nine that came out of girls who had experienced assault. So, and anytime somebody's tried to mess with Title IX, there's been a lot of blowback because bottom line, people like their daughters being able to have equality. So the only area where there have been issues now has actually been in the sexual assault area and men's rights and men weaponizing Title IX, essentially, to say that they are being discriminated against by being dismissed from their school programs or whatever for having engaged in assault. And that gets into messy areas of what kind of process their school engaged in to do that. And there have been complaints about all sorts of affirmative action. American Enterprise Institute, someone there filed hundreds of complaints with the Department of Education, which we consider frivolous, but which involved pretty much anything that involved doing something positive for girls that did not actively include boys.
Right. I'd like to piggyback on what Amy said about the blowback, and that there seems to be some move for defamation suits by those who are accused of sexual harassment. I don't know if that's a Johnny Depp follow-up, but it's terrible to think about how survivors have to face claims of defamation on top of due process requirements, facing courtroom-like procedures. It makes you realize how very, very difficult and how brave the survivors have to be to file complaints of sexual harassment.
Yeah, there's a case pending now that the Second Circuit referred to the Connecticut Supreme Court, Conn v. Yale, where Yale expelled a male student for sexual assault, and he is suing the complainant for defamation. He's also suing Yale for breach of his contract with them to give him his education for $6 million, I believe it is. So yeah, it takes a lot, and it's complicated. because Yale is a private school. If Yale were with public schools, the standards are somewhat different because the Constitution clearly applies. And but Yale is a private institution. So what limits and what rules they have and whether it was adequate to be considered process for him are something that we wait to see. The briefing has just been finished. See what the Connecticut Supreme Court has to say. But it is a nationwide problem.
I want to thank our presenters so very much for the wonderful insights and challenges for the future. Thank you very much. Is there anything else that anybody has to say?
I would just echo, I think Ms. Katz just said, excellent program, really enjoyed it, and I learned things. I thought I was pretty well acquainted with Title IX, but I just learned so much about the history and currently what's going on with current lawsuits. It's astounding. It's astounding that we're still fighting this so many years later. That's all. Thank you to the organizers and the speakers.
Thank you, Anne, and thank you, the presenters who have stayed with us. Best wishes for Title IX. Let's hope we have even better news at the next anniversary, the 5-year anniversary, which the coalition usually celebrates with a report. And let's hope to make progress on issues like Title IX, certify the Equal Rights Amendment. So thank you all. Our next meeting will be in September.